Hello and welcome to the View from Mayor Brown podcast. This is a fortnightly podcast series for employment lawyers and HR practitioners which highlights developments in case law and legislative changes of importance to UK employers. It is presented by Nicholas Robertson, the head of Mayor Brown's London employment team. The time spent listening to these podcasts can count towards your CPD requirements, and at the end of the podcast we will explain how to get in touch if you wish to claim CPD points or if you have any comments or questions.
Hello and welcome to podcast number 67, ticking along now. In this podcast we're going to be discussing three cases as is usual. The first, well, it looks at the steps that an employer is required to take to satisfy an employment tribunal that it's done all it could to determine whether an employee has a disability. Secondly, we've got a case which deals with the tax treatment of compensation for an injury to feelings claim, and that is an important issue. And the AT, they take a slightly inconsistent approach to the tax tribunal cases. The third, the final case, deals with service provision changes under TUPE and clarifies that a group of clients, who are all separate legal entities in their own right and have individual contracts with the service provider, could together be viewed as a client for the purpose of determining whether there's been a service provision change for the individual's employment to transfer under TUPE. At the end of this, I'm going to also like to say a few words about a special podcast episode that we're going to be doing later on this week, and that will come out next week, i.e. week of 30th March, to do with international employers and global mobility. Finally, I would just like to remind people the various ways in which this podcast can be accessed. In addition to being available via iTunes and the Mayor Brown website, it's now possible to access it via YouTube. Search on UK Employment Lawyer Law-Mayor Brown, otherwise you'll get John Mayer singing Brown Sugar. Trust me, I tried. Links to all of the cases are available from my Twitter account, which is Nicholas Robertson at Nicholas Rober, then the number 1 and the number 1, so Nicholas Robber 11. So, to business. So the first case is Donnellian and Liberator UK Limited, Donnellian, Donelien. This is an EAT decision which considers whether the inquiries made by an employer to determine whether or not the employee was disabled were sufficient for the employer to satisfy the tribunal that it had no knowledge, actual or constructive, of the employee's disability, even though the employer hadn't clarified a number of unanswered questions in the occupational health report. Under the Equality Act, employers are required to make reasonable adjustments for employees who are disabled, provided they have knowledge of the employee's disability. Section 6.1 of the Act provides a definition of disabled, and for an employee to succeed in a claim for disability discrimination, the employee has to demonstrate either that they have the disability and the employer has to have had knowledge of that, or the employer has constructive knowledge of that. And obviously that's to avoid employers willfully turning a blind eye to things. Following the case of Gallup and Newport City Council, it's well established that in reaching a decision regarding an employee's disability status, an employer cannot simply rely on an opinion given in an OH report. In the occupational health report in Gallup, the employee's medical condition was considered to be work-related but not to meet the legal definition of disability. No further detail was provided by the report, no reasons were given for the conclusions reached in that case. The employer in Gallup argued that in view of the information in the OH report, it could not have had actual or constructive knowledge that the employee was disabled, and as a result, the duty to make reasonable adjustments could not have been triggered. The Court of Appeal in the Gallup case disagreed, concluding, where an employer takes advice from external clinicians, it should be asking questions that are practical, as well as asking the medical advisors to consider whether the employee is disabled within the Equality Act definition. In the Gallup case, it was stressed that there is a need for the employer to make sufficient inquiries and to form its own judgment on whether the employee is disabled, as opposed to solely relying on the occupational health report. In Gallup, it seemed the employer dismissed the employee on the grounds of the OH report alone, so he lost. What was the position in Donnellian? Well, Donnellian had been employed for nearly 11 years at Liberator before being dismissed without notice for unsatisfactory attendance and failure to comply with Liberator's absence procedures. During her employment, she claimed to suffer from several medical conditions, including work-related stress. However, to complicate things, she did not suffer from a condition giving rise to consistent effects. It is often unclear whether the conditions were related. In her last year of work, she was absent on 20 separate occasions for varying reasons. came to something like 128 days. And so in the words of the tribunal, she was rarely at work. The Liberator contended it was difficult to disentangle that which she could not do because of her disability and that which she simply would not do. Before her dismissal, Liberator requested GP letters relating to her absences, return to work meetings were arranged, in which her condition was discussed, and she was referred to occupational health, and they were asked 6 questions related to health and potential disability. However, the OH report did not really answer those questions, and this prompted Liberator to make further inquiries, after which they got a further and more detailed opinion from the advisor, the OH advisor. Ms. Donnellian's issues were presented as predominantly managerial rather than medical, and the OH advisor's opinion confirmed that she was not disabled, a view which chimed with the employer's own experience and impression, to use the term of the tribunal, at the time. Following her dismissal, she brought a claim for disability discrimination and failure to make reasonable adjustments, alleging that she was disabled by reason of some 7 different medical conditions. Well, the Employment Tribunal dismissed her claim on the ground that the advice Liberator received from occupational health meant that it was reasonable for it to conclude that she was not disabled, particularly given the report was consistent with Liberator's own knowledge at that point in time. Tribunal went on to consider the inquiries made by Liberator to investigate the alleged disability. On this point, the Tribunal examined Liberator's own reasoning at the relevant time and looked to identify the opinion actually reached by Liberator itself in the light of the information that it had. And the Tribunal concluded that, well, Liberator had done all it could reasonably do to investigate her disability. There were 9 records of meetings following her return to work, a large amount of material, discussions, GP letters, return to work meetings, etc., which assisted Liberator in coming to its view. Well, Ms. Donnellian appealed the Tribunal's decision, and this was on the grounds that Liberator relied unquestionably on the OH report, and it could reasonably be expected to have known about her disability. The AT's decision therefore turned on the test of constructive knowledge, which is often expressed as asking what the employer could reasonably be expected to know, or it ought to have known. The AT rejected her appeal, with its conclusion being partly factual but largely evaluative. The AT considered the information that was available to Liberator at the time Ms. Donnellian was dismissed, including the medical advice in the OH report. In respect to the report, the AT considered that it failed to provide a satisfactory explanation for its conclusions, and therefore Liberator would not have been able to determine whether Ms. Donnellian was disabled from this information alone, and whether that disability had an adverse impact on her. However, the AT recognised the difficulties in practical terms faced by Liberator in relation to her various and often unrelated conditions, and the Tribunal held, in the circumstances, Liberator had given a lot of consideration to the issue of the question of her health. It had considered different sources of information when coming to its decision, and although the AT felt that Liberator might have followed up on the unanswered questions which they put to the OH advisor, to single out one small particular against the picture painted as a whole from the range of information Liberator had available to it, and the number of inquiries it had made, it would have been wrong in the AT's view to hold that it had constructive knowledge. The AT therefore concluded the Tribunal had taken the correct approach, and that the company could not be said to have had constructive knowledge of her disability, therefore her claim failed. I think the case is a useful one for employers. It provides some reassurance on the extent to which an employer is required to make inquiries to satisfy the Tribunal it has taken all steps reasonable to establish whether the individual is disabled. An employer can take some comfort from the case that a tribunal will view its consideration of an OH report in the context of all the other actions it's taken. However, the case also serves as a reminder that if an employer is to satisfy the tribunal, it's crucial that it questions the information it has on the employee, makes follow-up inquiries where there are gaps in the information, and doesn't just rely unquestioningly on any OH reports or other advice in coming to its decision. If an employer cannot demonstrate that it's relied on information other than the OH report, which it accepted unquestioningly, and hasn't done all it can to reasonably make further investigations into any issues raised by the OH report, then, as the Gallup case indicates, it may well struggle to show that it doesn't have constructive knowledge if it turns out, subsequently, that the employee is able to show that at the relevant time they were disabled. So that's the case of Donnellian and Liberator UK Limited. So then, next case is Timothy James Consulting Limited and Ms. Wilton. This is an EAT decision concerning, well, it had several grounds of appeal, but for the purpose of the podcast, I'm just going to focus on the EAT's decision, dealing with the taxation of discrimination awards. And it's a decision which saw the EAT disagree with the approach taken in a recent tax tribunal decision. Well, as a general rule, as we all know, payments which are made in connection with the termination of employment are subject to income tax, say for £30,000, which is the tax relief on termination payments, ignoring contractual payments for a second. The issue of how awards of compensation for injury to feelings are taxed on termination of employment has been unclear for some time now. Pausing here, there appears to be much less uncertainty about the taxation of injury to feelings awards where the discrimination occurred during employment. HMRC's own tax manual indicates that such awards are exempt from tax. There may be an issue as to whether it is permissible to allocate larger sums to such a settlement under the head of damages than an employment tribunal would have awarded. That's a separate point. The issue for this case, the case that we're discussing, is injury to feelings awards connected with the termination of employment. Part of the difficulty is you have two different strands of cases. You have the tax cases from the tax tribunals, which themselves don't speak with one voice. And you have the Employment Appeal Tribunal, which have considered this question in this case and in an earlier case, Orthet Limited, and which takes a different approach to the tax tribunals. Might help to deliver a pot spoiler at this point. Guess what? The tax tribunals are far more likely to say the award is taxable than the Employment Appeal Tribunal. But, in all seriousness, it may help to look at this in a little more detail. The relevant legislation is now the Income Tax, Earnings and Pensions Act 2003. There are two key provisions. Section 401 says, quote, "The payment which is received directly or indirectly in consideration or in consequence of or otherwise in connection with the termination of a person's employment," unquote, is taxable, but there is the £30,000 tax relief, in brief. Section 406 says, quote, "This chapter," which covers section 401, I'd add, "this chapter does not apply to a payment or other benefit provided on account of injury to or disability of any employee," unquote. So the question in essence is, do you start with section 406 and say that payments on account of injury or disability cover pain and suffering awards for discrimination? Or do you start with section 401 and say that these payments are in connection with a termination? In the case of Murthy and HMRC last year, the first-tier tax tribunal looked at this issue. Mr. Murthy had been dismissed on grounds of redundancy, following which he brought unfair dismissal and age discrimination claims. Claims were settled in mediation for a figure of £200,000. There was an injury to feelings award in there. Mr. Murthy claimed the full £200,000 was not taxable because it wasn't a payment made in connection with the termination of employment. In relation to the compensation that was payable in respect to the injury to the feelings award, he also said that that specific sum should be tax-free. HMRC argued the whole payment would be subject to tax, apart from the £30,000 exemption on termination. And in addition, they allowed a further £30,000 tax-free exemption in connection with the injury to feelings claim. But tax tribunal disagreed, considering the whole amount to be taxable, apart from one £30,000 exemption, the normal one. They concluded that HMRC didn't have the right to provide for an additional £30,000 tax-free concession for the injury to feelings award. Tax tribunal that said that where the discrimination is the act of termination itself, the payment is to be treated as fully taxable because the payment is directly concerned with the termination of employment. However, this approach, the Murthy approach, wasn't consistent with two earlier cases. Orthet Limited, the EAT decided that an award for damages for injury to feelings should not be grossed up because it wasn't taxable. And that in turn was based on an earlier tax tribunal decision of Oti Obihara, OTI-OBIHARA, and Commissioners for HMRC, which asserted that to the extent that any part of a settlement payment was damages for injury to the appellant's feelings or the consequence of discrimination, that wasn't taxable, even if it was paid on the occasion of the termination of the employment contract. So, how did the decision taken by the tax tribunal in Murthy compare with this case? Well, let's just deal with the facts. They're very simple. Ms. Wilton resigned from the consulting company, claiming constructive dismissal and sex discrimination. In the remedy hearing, the company was ordered to pay Ms. Wilton damages for injury to feelings of £10,000. The tribunal grossed this up to take account of income tax at the rate of 40%, taking the figure to £16,666. The company appealed the tribunal's decision to gross up the damages for injury to feelings on the ground that such an award is not liable to tax. So why did the EAT decide here that payments for compensation for injury to feelings were not taxable, so they didn't need to be grossed up, and the company effectively saved £6,666? Well, they relied heavily on the Orthet decision, which considered in detail whether the award was taxable. The Orfit decision pointed out that the well-known vento bans for compensation for pain and suffering in discrimination cases were set without reference to tax being payable. The Judicial Studies Board guidelines, which conducts an assessment of awards and which underpins the vento bans, also makes no reference to tax. The tax statutes say that payments on account of, quote, injury to or disability of the employee, unquote, are excluded from tax, and the EAT determined that the construction of the statutory provision here allowed a wide interpretation of the term injury, and that was capable of including injury to feelings caused by acts of discrimination. Putting all this together, I have to say I think the EAT's reasoning in this case is pretty compelling. It does seem very odd to assume that because a payment is a termination payment, it's therefore subject to Section 401, and Section 406 clearly excludes payments on account of injury, and awards for pain and suffering caused by discrimination are clearly a form of injury payment. But that's just my view. However, the EAT acknowledged that its decision on this point might have little practical difference in any event, given that the company agreed to indemnify Ms Wilton in the event that HMRC pursued her for tax on the award of damages for injury to feelings. But I think this is an important decision for employers generally. The case does create a great deal of uncertainty in this area, although I suspect HMRC will want to follow the case of Moorthy in preference to the EAT decision. Until the conflicting decisions are addressed, employers would be wise to ensure that appropriately drafted indemnities are included in their settlement agreements in respect of the potential tax liabilities, particularly in connection with acts of discrimination which are directly linked to the termination of employment. And these points do often come up in settlement negotiations. That's the other place we see them. It's one thing to see them in a tribunal case. Do you gross up or not? But we often tend to see these in the context of settlement negotiations. Claimant lawyers will often want a sum of money apportioned to injury to feelings awards so they can claim more on a tax-free basis. Whilst there appears to be no dispute about that in relation to pre-termination discrimination, we can see from this that discrimination connected with the termination of employment is clearly much more risky to treat that as a tax-free payment. In my experience, employer lawyers will usually refuse to make such allocations because, however it's phrased, it's seen by the employer as an admission or corroboration of evidence that discrimination occurred, and no employer will tend to stand for that. But this case does indicate that there are uncertainties around the tax treatment of compensation payments for pain and suffering on termination, and so may indeed encourage employers to push back on that idea too. So, that's the case of Timothy James Consulting Limited and Ms. S. Wilton. The third and final case is Otomo Property Services Limited, Duncan and Another. This is an EAT decision looking at service provision changes and the application under TUPE in the context of multiple clients and contracts being involved. Well, just by way of background, the legal provisions under TUPE provide that service provision change can occur when, quote, activities cease to be carried on by a contractor on a client's behalf and are instead carried out by another person, unquote. In the case of Otomo, the EAT had to consider whether the reference to, quote, a client, unquote, for the purpose of a service provision change was to be understood solely in the singular, or whether it could allow for there to be more than one client, provided they remained identical before and after the alleged transfer. Mr. Duncan was employed as a site manager by Otomo on an estate that had different blocks of residential housing. Each block had a separate residence management committee, each management committee constituted a separate legal entity, and there was a separate general management company which dealt with the common parts of the estate. Otomo provided property management services to a number of the residential housing blocks, and also to the general management company, until a company called Warwick acquired all but one of Otomo's property management contracts. Warwick employed a new property manager, but did not consider Mr. Duncan for the position because it had been advised that TUPE did not apply. Mr. Duncan was dismissed and claimed that TUPE did apply. And the Employment Tribunal considered whether there had been a transfer of the business as a going concern, i.e. the ordinary European test for a transfer, and decided there had been no such test, no such Spikers test. They noted the business had effectively fragmented because some of the residential blocks had ceased to form part of the contracts that were maintained by Otomo. There was no economic entity, they said, which retained its identity, so there was no transfer of assets or employees under the ordinary TUPE test. So the question then was there a service provision change when Warwick acquired the property management contracts from Otomo, and whether Mr. Duncan was part of the organised grouping of resources or employees in question, so that TUPE applied. The tribunal found there had been no such service provision change. It disagreed with Mr. Duncan's argument that the word client should be considered in the plural, and where, as was the case here, several different clients are changing service provider, these changes should be considered together as a single, larger service provision change. The Employment Tribunal accepted that each individual property management contract could have contained an individual service provision change. However, the problem here was that Mr. Duncan was not assigned to any individual property management contract. He was assigned across all of those undertaken by Otomo. Well, Mr. Duncan contended that as one single service provision change occurred here, he didn't need to show he was assigned to one of the individual management contracts making up the bundle that was transferred to Warwick. He claimed that you could look at it across the piece, look at it holistically, and that TUPE applied to transfer his employment because he was assigned to one larger service, i.e. all of the Otomo contracts that had been transferred. The tribunal considered whether there was a service provision change, but decided it's not permissible for a number of contracts with different clients to be added together to make one overall service provision change. And that they stated that the relevant wording under TUPE clearly refers to a client and the client throughout, which means a single client is being referred to, not a group of two or more clients. Mr. Duncan appealed to the EAT, who overturned the tribunal's decision. For the purpose of this podcast, I'm just going to look at the question of whether or not there was a misdirection by the tribunal in relation to the true meaning of client under TUPE. The issue the EAT considered on this point were accepting that the client must be the same before and after, which we've learnt from other case law. What if the client is comprised of more than one legal entity? Can the client for service provision change purposes only be understood in the singular, or can several different clients who use the same service provider but operating under separate contracts be interpreted as one client for the purpose of the regulations? EAT decided there was no reason in principle why the client must be a single legal entity for these purposes, and they gave the example of where a service provision change might involve a contract for the provision of particular services drawn up between a contractor and a group of persons who are collectively defined as the client under that contract. And given that this provides for a service provision change under the regulations, there was nothing in the regulations to evidence an intention the singular couldn't include the plural here too. The identity of the client or clients must remain the same before and after the service provision change, but this might involve more than one legal entity, subject to the caveat from the AT that it would still need to be possible to identify a common intention of the combined client, if I put it in those terms, for the purpose of the regulations. The AT clarified it did not mean there had to be a single contract between the legal entities comprising the clients on the one side and the contractor. It must be possible to identify a common intent. The AT concluded the absence of one single contract between clients on one side and the service provider on the other would not necessarily be fatal to the finding of some link, some commonality between the clients in question. The case was then sent back to the tribunal to decide whether there was sufficient commonality here. I think this case is an important one and a very sensible one. It's important because it's quite common for, say, cleaning contracts to be provided to an office block. It may have a number of different tenants in it. If each of those tenants contracts separately with the cleaning contract rather than, say, through a management services company, this case is going to be very relevant in deciding whether or not there are service provision changes in the event that the tenants get together and decide as a block they want to get a different cleaning company involved. It's also noticeable that service provision change rules applied here even in circumstances where the ordinary TUPE test was found not to apply. That, of course, is the object of having the service provision changes, to provide clarity where there are grey areas. And the court said, in relation to service provision changes, there was no need to adopt a purposive interpretation here, because that's not generally the way service provision change rules, which don't derive from Europe, operate. But the natural reading, according to the AT, would indicate that if there is a common interest and a common purpose, and the clients, the basket of clients, remain unchanged before and after, there can be a service provision change. I think there is still some uncertainty for employers. Clearly, employers must now be conscious that they probably need to look at a bigger picture for service provision changes and not look at contracts in isolation. Here, Otomo, the transferor, might well have thought there was a series of individual service provision changes with no employees affected. It was but, according to the EAT, it was necessary to step back and look at the bigger picture. But what would have happened if one of the 6 residential blocks had not transferred to the transferee but had gone to a third party? Would that have removed the common intent of the other 5? or was that merely by taking 1 out of 6 companies out, would that be enough to defeat the existence of this the basket client before and after? 1 out of 60, 1 out of 600 clients. You can increase that question infinitely. We know that the identity of the clients has to remain the same before and after, but I wonder whether there is a de minimis will be permitted, that it's possible to identify the commonality even if one client drops out. We'll see. In the short term, it does mean this is an additional point for employers to be aware of when considering tests for transfer under service provision changes. So that's the case of Otomo Property Services Limited and Duncan. Finally, I did just want to say a few words about a special podcast we're doing, which will be out next week, with Liz Stern, who is the head of our global immigration and mobility team. One of the things that's becoming increasingly apparent to all employment lawyers who act for larger employers is the extent to which a globally mobile workforce is now an essential part of business. We've been looking at a number of the issues which can face employers who are looking to move employees, whether they're very senior employees on secondment or lower paid employees as part of a larger scale project. Liz will be answering some questions based on how her extensive experience of the sort of issues that employers can face, how that experience has assisted in finding solutions to some of the more tricky problems. I'm sure it's going to be an extremely interesting podcast. So please do join us for that next week, and then the week after we'll be back into the normal run of things. And finally, I think it just remains for me to say, well, first of all, thank you for listening, and of course to confirm that, as always, no employees were harmed or otherwise mistreated in the making of this podcast. Thanks very much.
So that was our latest podcast. We hope you found it useful. If you have any questions or comments or want to know how to claim CPD points, please email Nick at nrobertson@mayorbrown.com. Our podcasts are an overview of the cases, and how the law applies in any particular case will obviously depend on the individual circumstances. So please take legal advice if any of the matters discussed are relevant to issues you are dealing with. Thanks for listening.